Okay, we've got everybody connected for the 145 hearing. This is Ronald Langer versus Secretary of State, file number 2511932. If I could have counsel put your appearances on pause.
Crawford County Prosecutor Sierra Koch.
Thank you, Your Honor. Jason Thompson, representing the petitioner, Ronald Langer.
All right, thank you. Mr. Thompson, I did receive your brief along with all the supporting documentation that was submitted. I had a chance to review all of those materials, including the ruling of the hearing officer, most recent one, the one before that, all the materials that were contained and attached as exhibits to those hearings. I also received a copy of the transcript. I had a chance to read through that. So I have all that information. Ms. Koch, I did not receive any kind of written brief from your side. Are you, or what is the position of the people with regard to the petition?
The Secretary of State's office did not do a response. We cover these hearings for them. They provided a statement believing that this court has jurisdiction and that they wished that the order from the hearing officer be upheld. Having read through that order, it looks like his feelings were that, overall that he didn't meet the requirements, and essentially they didn't like the letters. The evaluation wasn't good enough. But I think the real issue is that he had it previously, and he screwed it up. So, I would defer to the court whether or not they feel Mr. Langer, this court's already read all of this, so I don't need to repeat any of it, has met his burden or not. Thank you.
All right, thank you. Mr. Thompson, as you're aware, the court can't take any type of evidence here today. The court has to rely on the record before the hearing officer, but did you have any oral argument you wish to make?
By argument, Your Honor, obviously Mr. Langer isn't subject to any kind of lifetime ban because of what happened in 2019. He had a .04. He pled to that. He served his time for that. We believe that the factual record does establish that he is sober and that he's been continuing sobriety. We think the hearing officer was unfair and unfairly limiting in refusing to consider the letters that were submitted in good faith and was openly hostile to Mr. Langer and his testimony. We would just want to remind the court that what we're asking for here is an interlock license. So Mr. Langer would be monitored at a higher level than any other citizen while he drives. He would have to continuously blow clean. He would have to provide clean blows to operate that motor vehicle, and we think that would sufficiently protect the public safety. Mr. Langer is not a drinker. He has a background, the court's familiar with his record, but I think the testimony at the hearing firmly establishes that he is an impaired for a lot of license. Thank you.
All right, thank you. Again, I did review all of the materials. First of all, with regard to the standard, the court, this is not a de novo review as the attorneys are aware, and the court is not in a position to make its own decision or to arrive at its own conclusions in this case. Even if I would have come to a different result than the hearing officer, under the standard of review, I'm not to substitute my own judgment. The court is merely to review the hearing officer's determination under a number of different factors. The challenge factors here are that decision was not supported by competent material and substantial evidence on the whole record, and that it was arbitrary, capricious, or an abuse of discretion. So the court standard of review is to determine whether or not it is supported by evidence and that it is not an abuse of discretion. And that is a relatively low standard and accords a fair degree of deference to the hearing officer's decision as the one who heard the live testimony, had an opportunity to make credibility determinations and so forth, which I don't have the benefit of. So that's the standard that the court's looking at. In terms of the hearing officer's decision, in my view, the hearing officer's determination was made based on essentially two deficiencies in the petitioner's case. Number one, with regard to the substance abuse evaluation, the hearing officer felt that the testimony that was given was inconsistent and or lacking certain details compared to the information that was given to the substance abuse evaluator, and in particular things such as his prior conviction history. And so the hearing officer made the determination that because the information given to the evaluator was at the very least inconsistent, perhaps not accurate, that undermined the evidentiary value and the probative value of that evaluator's decision and prevented the hearing officer from being able to determine that the petitioner had met his burden of producing clear and convincing evidence that his abuse or substance dependency was under control and likely to remain under control. The second basis that the hearing officer offered was that the support letters that were submitted, the testimonial letters, did not contain sufficient detailed information about Mr. Langer's underlying substance abuse. And so for those reasons, the hearing officer determined that he had not met his burden. I had an opportunity to review both the testimonial letters that were submitted as well as the evaluation. And again, I did review the testimony by transcript. The court finds that there is a basis for the hearing officer to have concluded that there were at the very least inaccurate or incomplete facts, and that there were inconsistencies in terms of Mr. Langer's testimony versus what he had previously reported and what his driving record reflected. I also reviewed the testimonial letters, and again, it's sort of a judgment call. The hearing officers are looking for very particular information under the standards that they're defined. I can't say that those letters were, or that the hearing officer's determination was so outside the scope, and that he didn't have, an arguable point with regard to the content of those letters. So again, it really comes down to this court's review. It doesn't matter whether I would have made a different decision if I was the hearing officer. Again, I find that the hearing officer did base his decision on evidence of inconsistencies within the record, and that the hearing officer, his determination with regard to the content of those letters was not so far off that the court could find that it was an abuse of discretion or that it was arbitrary or capricious. Otherwise, the court finds that the hearing officer cited the correct statute and regulation, that he accurately applied the law in this case. So for those reasons, the court finds it does not have a basis to overturn the ruling of the hearing officer. So the court is going to deny the petition, and Mr. Thompson, if you would prepare an order that reflects the ruling of the court today, in case Mr. Langer wants to pursue further appellate relief.
Okay.
All right, thank you. That's all for this hearing today. All parties are free to disconnect at this time. All right, ma'am, are you Andrea Martin? Oops, I need you to unmute, please.
Can you hear me now, Your Honor?
I can, yes,
Yeah.
thank you.
I am Andrea Martin.
Okay. This is Martin versus Sangwan, file number 2512001. The record should reflect that Ms. Martin is present here by Zoom video today. Ms. Martin, I have this set for entry of a default judgment of divorce today. Is that how you wanted to proceed?
Correct.
Okay. I'm going to place you under oath. I've got some questions that I need to ask you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. If you would raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Yeah. Okay, sorry about that, Ms. Martin. Ms. Martin, my first question, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Correct.
At the time you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Correct.
Had you been a resident of Crawford County for at least 10 days?
Correct.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Correct.
Does that remain true today?
Yes, Your Honor.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No, Your Honor.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor.
The judgment also indicates that you don't own any real property with the defendant. Is that correct?
Yes, Your Honor.
And that all debts and other personal property have been divided up between the two of you. Is that correct?
Yes, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Martin. I reviewed the file prior to today's hearing. It does appear that the defendant was properly served with the summons and complaint. The defendant failed to answer or otherwise defend. The defendant was defaulted. The defendant was provided with notice of the date and time of today's hearing, which was 1:30. It's now 1:47. Defendant has not appeared either remotely or here in the courtroom in person, so the court finds it would be appropriate to enter the default judgment of divorce. I've signed that judgment, so Ms. Martin, that means that your divorce is final as of today.
Thank you, Your Honor.
Did you have any questions?
No, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.